और कहाँ है वो? हाँ हाँ that so that I can Good morning.
Good morning, sir.
Good morning, sir.
First of all, let me congratulate all of you for taking some time to be a part of this Oriental program. On the other hand, I extend my heartfelt gratitude to Professor Madam Malini and Professor Nanjun Swamiji for giving this opportunity to share few views on public interest litigation in India. Perhaps you may have gone through the crux of the subject, why public interest litigations are actually being filed before Honorable High Court and Supreme Court. What is the reason behind why public interest litigation shall be looked into? No matter, an insight into the subject matter of public interest litigation is not so simple. It requires a lot of drill to understand each one of them. Just have a look on. It is a legal action in the court of law for the protection of a public interest. What is public interest? This has to be looked upon. Being a teacher, perhaps we may have gone through so many crises in the world. There are series of crises in the world, and unimaginable proportions of problems are being continued till now. Sometimes you may not be finding solutions as well. With a view to understand some solutions, what is to be done, and how best the courts are helpful to you to clear some doubts in connection to the subject matter of women, children, orphans, LGBT sex, problems in connection to the protection and preservation of human environment, problems in connection to child labor, bonded labor, then human trafficking, crisis in connection to the subject matter of above all environment as well. With a view to overcome all these, first of all, we have to understand why public interest litigations are being filed before Honorable High Court of Karnataka under Article 226 and 227 of Indian Constitution. You'll be moving to Honorable High Court. Under Article 32 of the Constitution of India, you'll be moving to Honorable Supreme Court to understand the crisis in which you are surrounded. Of course, no matter, it is highly philosophical. When you are close to high temperature, you will find high fertility. When you have got high fertility, population will be increased. When you have gone through population, obviously, problems are many. So this is my hypothetical answer I'm just sharing with you. However, it requires a lot of drill to understand this crisis as well. This is one thing. On the other hand, in earlier days, you had a huge natural resources, less population. Now you have more population and lesser natural resources. That's why you are quarreling each other to share the natural resources as well. In earlier days, if you just look into European models or European issues and challenges, we had 30 years of war in Europe. It was a religious war, as I believe. There was no scope for protection of human rights and fundamental freedoms during this era as such. To overcome all these, Treaty of Westphalia 1648 came in Europe to resolve some disputes in connection to the subject matter of the war situation as well. And you know that better than me, entire Europe was a battlefield. There was no scope for protection of human rights, fundamental freedoms, or such other directives as you have witnessed under part 3rd and part 4th of the Constitution of India. You know that understanding Constitution is not so simple. It requires a lot of drill because it's not at all a drama or a story or a novel. Sometimes people will read Constitution, they are not understanding. Sometimes they read it, they know how to understand it. When it comes to the knowledge of interpretation of statutes, they will be failed in interpreting the Constitution as well. Sometimes people may have gone through all in all. They know how to read it, they know how to interpret the Constitution. But the fact that the moment when they are sitting at the higher level, look at their sweeping statements or safe cornered statements. So these are the crises we have country like India. How to overcome and where exactly you can find peace at this juncture. You know that peace, it does not mean it is an absence of war. Peace means presence of justice. We need to have a justice. It could be either distributive justice or corrective of justice. We need to have it. However, you may have come from certain backgrounds. That justice has to be shared to the people who are left out in the society. I mean to say triple justice. Triple justice in the sense that political justice, economic, above all, social justice. So these are the aspects which shall be resolved. I mean to say that the fruits of justice should be shared to the people who are left out in the society as a whole. We have to give voice to the voiceless, eyes to the eyesless, remedies to the remediless. Look at Article 32 of the Constitution, wherein it has outspoken on right to remedy. Right to remedy, that itself is a fundamental right. So without understanding remedies, how will you enjoy rights which are guaranteed under Part 3rd of the Constitution? That could be read out with Part 4th. The Part 4th, which has been in fact dealing with directive principles of state policies. And some say that directive principles of state policies are mild laws which cannot be enforceable before the court of law. Sometimes they may be called as if a soft law. Then you can put a fundamental question. What is soft law all about? Why soft laws are created? And you know that in absence of hard law, then the soft law will play an important role. That is our reasoning by analogy. I agree with you. 100% I'll agree with you. Not an issue. But the fact that the moment when you are implementing law, you'll be finding a lot of crises. Then what kind of crisis you have? Barriers you have? Problems you have? So these are the things which shall also been actually verified and looked upon. when you are just dealing with the public interest litigations are concerned. What is the purpose behind? Why are you filing public interest litigation before honorable courts? And you know that public interest litigations, they aim to facilitate common people to access courts to seek redress in legal matters. It is a crucial tool for social change, accelerating the attainment of justice and law, in fact, upholding the rule of law. This is very important from the point of view of understanding the rule of law. What is rule of law? Rule according to law. Nobody is actually above the law. Even king also under the law and God. This is what Lord Denning has already been outspoken. You know that Raja Pratyaksha Devata, that concept was actually overruled when Magna Carta was initiated in 13th century in Europe. King can do no wrong is a wrong perception. Sun never sets on the British flag. It is an obnoxious ideologies of UK. I mean to say that European systems that has to be looked upon. And moreover, if rather I would say, king can do no wrong, as I believe it's a wrong perception. He can also commit mistakes. He is not above the law. He may be superior. He may be sovereign. I agree with him. And who has passed the law? That's a fundamental question to be asked. If something has gone wrong by a state or from a state, and who is responsible? Who will pay for it? Ultimately, an individual is going to be suffered in the society as such. That shall not be there. So therefore, if something has gone wrong by a government, in such a situation, we can move to the court by filing writ petitions. There are so many writ petitions filed before honorable high courts and Supreme Court as well. Take for an example, habeas corpus you have, quo warranto you have, mandamus you have, prohibition you have, certiorari you have. These are the 5 writ petitions can be filed before honorable high courts and Supreme Court as well. So in this way, lots of responsibilities are shouldered on few people who can share the problems of the general public as well, through which you can seek a justice. So justice cannot be bought in any mega stores or Mall of Mysore or in a hotel as such. You should understand that the justice, where exactly justice can be derived. You are a better judge. Judge what is right and what is wrong. What is good for me may not be good for you. What is right for me may not be right for you. Of course, there is a room for discussing all these issues and challenges as well. And something has to be looked upon. Simply, you cannot say that who bells the cat? Who bells the cat? It is an obnoxious ideology. Even today, it is remained. I must share with you, being a student of law, in which I have studied constitutional law and international law as well. You have to catch the cat, bell the cat, and watch where exactly it is moving. It means that if X happens, then Y ought to happen. If X commits a crime, he should be prosecuted mercilessly. This is what Jeremy Bentham, when he was actually dealing with utilitarianism, he could share his views. If X happens, then Y ought to happen. If X commits a crime, he should be prosecuted. Generally speaking, he should be prosecuted mercilessly. Whoever may be, nobody is actually superior or inferior. All are equally footing. This is what Article 14 of the Constitution of India has already been outspoken. Look at equality before law and equal protection of law. They should go hand in hand. Like should be treated alike. Unlike should not be treated like. Equality before law and equal protection of law, they should go hand in hand. This is what the Constitution has already been outspoken. Look at the preamble, part 3rd of Indian Constitution, which has been dealing with fundamental rights. Look at part 4th, has been dealing with the directive principles of state policies. There are so many parts, schedules, emergency provisions, amending provisions, state and central relations. You have federalism. You are from cultural background, multiculturalism, you have ethnic pluralism, you have all in all you have. Why you are not interested to implement the law practically? It's my fundamental question to be asked. This is one of the major crises we have. There are so many crises, I agree with you. You are all teachers. Perhaps you may be teaching the word crisis. Look at word hunger, starvation deaths, malnutrition, crisis in connection to women, children, orphans, crisis in connection to the protection and preservation of human environment. They're all actually remained even today. There are no sound solutions to overcome.
Sir, slide is not moving, sir.
Yeah. Look into the subject matter of transcendental crisis. I must share with you whether egg is first or hen is first. Plant is first. Seed is first. Military necessity is first. Humanity is first. Nobody is stronger. I believe in Chinese philosophy, wherein Lao Tse and Confucius philosophy, they have outspoken on the society as a whole. When the society changes, law has to be changed. This is what I'm just recollecting one of the statements given by Stephen Wago of United States, wherein he says that law is an instrument of social change. It may change from time to time as science and technological development. You know what kind of developments that are taken place at the international level. We have nanotechnology, information technology, marine technology, space technology, and such other developments that are taken place, which includes digital technology as well. Since you have been dealing with all in all, along with some terrorist activities around the globe, look into Lashkar Taiba, Taliban, Boko Haram, ISIL. Apart from these, you can have a look on world crisis like Yemen civil war, Syrian civil war, ongoing crisis in Ukraine, ongoing crisis in Georgia. Unimaginable proportions of problems are being continued. And where exactly you can find some solutions? It's my fundamental question as well. Through which, how exactly a constitution can be interpreted? You know that what is all about constitution as well. It has mixed with many colors. This is what John Will Austin has outspoken by saying that the Constitution of India is nothing but a social document as such. It's a social document which mixed with many colors and changes as well. So I'm just giving you some inputs to reach out the expectations of a PL, public interest litigations as well. How exactly public interest litigations can be filed before honorable high courts and Supreme Court as well. This is one thing. On the other hand, when you just look into the crisis country like India, how will you overcome them if something has gone wrong from a state as such? If somebody is actually crying at home, mother should know why he is or she is crying. Mother should know all these issues and challenges in a family. She is responsible to pay for it. So in this way, the states are responsible. If states violate international obligations, then the state responsibility would come into picture at the higher level as such. Then what kind of obligations are shouldered on you? Being a member country of a United Nations organization, lots of responsibilities are shouldered on the government as such, or the state as well. This is what draft articles on state responsibilities for wrongful acts 2001, which was actually drafted by 5 special reporters of International Law Commission, which has already been outspoken. It means that if a state violates an international obligation, then the state responsibility would come into picture. What kind of responsibilities are shouldered on you? You have become one of the member countries of UDSR, Universal Declaration of Human Rights, and you have already been signed International Covenant on Civil and Political Rights 1966, International Covenant on Economic, Social and Cultural Rights 1966. So based on that, in 1993, you were able to pass a legislation, country like India, the Protection of Human Rights Act 1993. Before 1993, we couldn't find a single definition on human rights. You just go through even the Constitution of India, human rights nowhere defined. But you have got a reasonable analogy. What you say? You say that all fundamental rights are human rights, but all human rights are not fundamental rights. That's your sweeping statements, as I believe. You're all human beings. The people who are sitting and witnessing me, they're all human beings. A person who is actually teaching on the other side is also a human being. However, you may have had some categorical distinctions and dichotomies, perceptions and ideologies as well. Look into the gravitational issues, country like India, unimaginable proportions of problems are being continued. This is one thing I should recollect based on PIL as well. Then you can put a fundamental question, sir, who can file a PIL before honorable courts? Any individual or an organization can file a PIL, public interest litigation, before the court of law. First of all, when you just appear before honorable courts, judge will ask why you have come to the court. On what basis you have come to the court? What kind of public interest litigation you have? Do you have vested interest or not? They will question everything. When you are just appearing before the court of law through your PIL, you should have some solutions. That's very important. You should state literally, stating that there is a gross violation of public interest litigation, Your Honor. Please allow our petition. So this is what an individual or an organization should acknowledge before the court of law. Otherwise, PL can be rejected within no time. PL should be filed before CJ, Chief Justice of High Court. Otherwise, it will be rejected. This is what one should understand. Who can file a PL, public interest litigation? Any individual. On behalf of public, on behalf of a general public, any gross violation of the human rights, fundamental freedoms, gross violation of, such other thing like, in connection to the subject matter of environmental crisis. In such a situation, you can file. I'll share some certain cases which are filed before honorable high courts and Supreme Court as well. Where can a PL be filed? Public interest litigations may be filed either before Honorable Supreme Court of India under Article 32 of the Constitution of India, or any High Court under Article 226 of the Indian Constitution. As these are the writ jurisdiction which are conferred under the Constitution of India. You know that Constitution that itself is suprema lex and lex specialis. Above all, if rather I would say, it is opinio juris. Without understanding Constitution, it's very difficult to file bail before the court of law. You have to understand the entire crux of the Constitution and where exactly the entire publics are actually affected, or group of people are actually affected. Then what kind of social interest you have, or public interest you have. All these things shall be cleared before the court of law. Otherwise, immediately a judge will reject your petition by saying that this case has no merits of the cases. So, such things shall not be happen when you are just filing, a public interest before the court of law. This is one thing. Then what kind of laws you have governing, PIL in India? PIL can be filed by any person for welfare of others who are disadvantaged. Look at the marginalized sections of the society or weaker sections of the society. Most of individuals are highly weak and marginalized. To overcome all these, this is one.
Serious
On the
about
other
the
hand,
dates of the study.
the general rule of locus
Start their
standi
study. Once they get the
has been
timetable,
relaxed
then
in
they will start their
the
study.
cases of PIL
Yes,
to
sir.
protect and safeguard the interest and rights of these disadvantaged.
Inform and MBA.
Disadvantaged people. They may be scheduled caste, scheduled tribes, women, orphans, LGBT sex. Look at human trafficking, alarming. Look at crisis in connection to the subject matter of environment as well. Series of crises you have. Unimaginable proportions of the issues and challenges are being continued. And you know that almost all the decisions of the government are always based on reports submitted by experts. Look into a crisis in connection to Western Ghats. You know Western Ghats. Western Ghats covered with 46 districts, 146 talukas, and 6 states, which has given good life to human being. But at the recent juncture, you can say that this is being butchered by many. With you to protect and preserve human environment of Western Ghats, we had a number of reports submitted by experts. Take for an example, Madhava Gadgil report, Kasturi Rangan report, and Oman Chandi's report. These are the reports are outspoken to understand the Western Ghats as well. You just see and visit as many as primitive tribals are actually living over here. Even apart from Western Ghats, just look into Eastern Ghats as well. Lots of tribals are living. They could be Jenu Kurba, Kadu Kurba, Bettadu Kurba, Soligas, Yarava, all these people are living over there. If something has gone wrong from few agencies, obviously you can bring it to the notice of higher authorities as well. The people who have been actually evacuated from these areas, even today, are not able to get a small place to live. They are highly marginalized and weaker. Of course, some agencies have been actually set up to understand these people. Take for an example, we have National Commission for SCs, National Commission for Scheduled Tribe, National Commission for Minorities, National Commission for Women. All these commissions we have set up on the basis of constitutional checks and balances. I agree with you. If something has gone wrong, how exactly problems can be resolved? This is very crucial. So therefore, being an individual or an organization who have come across with some public interest, you are liberal to file. And it is permitted under the law of the land. So that has to be looked upon. On the other hand, courts have treated even a letter or a telegram as a PL, as in the case of rural litigation and entitlement Kendra. Dehradun versus state of Uttar Pradesh. Even the law relating to pleadings has been actually relaxed by the courts in case of public interest litigations as well. Sometimes you may not be in a position to move to the court. In such a situation, you can write a letter to CJ, Chief Justice of India, to seize some of the cases immediately. This has happened in rural litigation and entitlement Kendra, none other than Dehradun versus state of Uttar Pradesh case as well. You can write a letter to Chief Justice of India to share few views on public interest as well. The courts have also highlighted the fact that Article 14 and 21 of the Constitution of India and the International Convention on Human Rights provide for a fair and reasonable trial. Therefore, the court must intervene when injustice is done to many as well. This has happened in many cases as well. Any gross violation of Article 14 and 21 of the Constitution of India, in such a situation, we can move to the court immediately. Apart from these, any gross violation of the rights which are guaranteed under Part 3rd of the Constitution and International Convention on Human Rights, in such a situations, also you can move to the court with social interest as well. This is one thing. Look into fair and reasonable trial. Fair and reasonable trial is also a fundamental right and human rights as well. If something has gone wrong to your fair trial, in such a situation, also you can move to the court as per as Article 226 and 32 of the Constitution of India. See, any question of maintainability, take for an example, government may not be allowed to raise questions as to the maintainability of a PIL if the court is prima facie satisfied that there is variation of any constitutional rights of disadvantaged category of people as well. Take for an example, any atrocities taken place or gross violation of human rights of women. Take for an example, domestic violence are taken place, any gang rape, marital rape, or rapes in general. In such a situation, you can also move to the court when there is a gross violation as well. So these are the things which shall also been actually looked upon. The principle of res judicata or any principles analogous to it would depend on circumstances, the facts of the case, and the nature of PAL as such. It means that similar cases shall not be filed in some other courts as well. If they are filed, immediately judge will reject your public interest litigation as such. When a case is actually filed before Honorable High Courts and Supreme Court, a commission can be appointed to verify all in all. It is permitted. Look at public interest litigations regarding the constitutionality, the validity of the statute or statutory rule. Ordinarily, the High Court should not entertain such petitions by way of PAL as well. It means that public interest litigations can be filed, no matter. But there are some restrictions when you are filing public interest litigations as well. Under Article 142 of the Constitution of India, the Supreme Court of India has the discretionary power to pass a decree or order as may be necessary to do complete justice. You know, justice, what is justice? Justice not only be done, it seems to be done. Your law looks as if a crude oil, whereas justice is a refined oil, less cholesterol, you know that. It could be distributive or a corrective of justice. This is what John Rawls in his theory of justice has already been outspoken on the concept of justice as well. As I said, the fruits of justice should be shared to the people who are left out in the society as such. Then the triple justice, social, economic, and political justice should be shared to the people who are left out in the society. So in this context, however, you may have had some confusion in connection to the subject matter of justice. Obviously, justice has to be rendered. And one should enjoy the right to life as stated under Article 21 of the Constitution of India as such. Article 21 of Indian Constitution that itself is a primordial right without which other rights cannot be enjoyable. This is what the caption of Article 21 of Indian Constitution is very clear. Look into the crisis country like India. Take for an example, internal displacement. We have more than 7 lakh internally displaced persons country like India. Even today, we are not finding some sound legislations to understand the problems of internally displaced persons. Except Article 21 of Indian Constitution, no law is there to protect, promote, and encourage human rights of internally displaced persons, country like India as such. So as compared to refugees, internally displaced persons in India, they are highly marginalized and weaker. To overcome all these issues and challenges, certain PAL can be filed before Honorable Court to resolve the problems in connection to internal displacement. Country like India, you just visit and see more than 280,000 Pandits who were migrated from Kashmir Valley. They are living in other parts of the country. They are highly miserable. Even today, they are not finding some food, clothes, shelter as well. And we talk many things on direct principles, state policies, and fundamental rights. I agree with you. There are so many rights are guaranteed to human being or citizen of this country. Look into these crises. Take for example, IDP, internal displaced persons are concerned. Unimaginable proportions of problems are actually being continued in India. These are the examples I can cite you. Look at the courts are extremely cautious to ensure that PAL are not misused, as the misuse of PAL would defeat the very purpose for which it was actually concealed. Sometimes individuals or organizations are going to file few PALs based on their vested interest. Private interest might be there. So in such a situation, obviously, if it is known to the court based on benefit of doubts, a case can be rejected, disposed of with no cost as well. So these are the restrictions we have. When you are just filing PL, you should be careful. You should have merits of the cases. You should have major grounds to file a case. Otherwise, a judge will reject your case immediately. So therefore, the courts have time and again reiterated this fact, as in the case of Kushum Lata versus State of Union of India. Certainly, a case can be rejected if it is not relying on public uh, issues or social issues are concerned. However, there is a class. The courts have held that even if the petitioner had approached the court for his own private interest, due to his personal grievances, the court may treat it necessary to inquire into the subject of a litigation and its state of affairs in furtherance of a public interest as well. Suppose there is a gross violation of the human rights and fundamental freedoms or rights. In such a situation, you can move. However, you may have been actually restricted to few observations as well. You know very well, better than me, law has got its own exception. That exception shall not be a general rule. This is one thing. On the other hand, self-consistent law is an illusion. There should be consistent with other disciplines as well. That has to be looked upon. And law is not actually shaped on its own. Law has been shaped on the basis of a preponderant interest of a common man. That has to be looked upon. This is one thing. On the other hand, a history of law or the society shall also be actually uh, known to you. Otherwise, it's very difficult to understand the crux of the public interest litigations as well. This is one thing when you are just filing public interest litigations are concerned. Look at in environmental law cases, the courts have formulated and evolved several concepts, including polluter pays principle, the precautionary principle, public trust doctrine, and above all, sustainable development. Apart from these, we have had series of principles evolved. Take for an example, common but differentiated responsibility, precautionary principle, intergenerational equity, common concern of humanity, common heritage of mankind. All these principles are evolved with a view to promote and encourage the human environment. So human environment shall not be butchered by anyone. You know that better than me. It is because of industrialization, privatization, globalization, internationalization. Many issues are being continued. I agree with you. However, there is a room for discussing all these issues as well. This is one thing. And on the other hand, protection and preservation of human environment is a matter of acceptability and the survival of our social system. One should have, concern towards neighborhood. That's very important. Sometimes it is categorically stated, your neighbor may not be your good friend. Your neighbor may be a good friend. I agree with you. However, this is the right time to understand your neighborhood. I mean to say that the environment as well. This is one thing. And you should grow naturally how plants and trees are growing. This is what philosophy is actually acknowledged to understand each one of them in the society as such. It means that don't be an artificial when you are just filing few cases as well. When you're just passing some specific legislations before Honorable Parliament, you shall not be an artificial. An artificial life should be condemned. And you know that an egoistic person will never ever die because he has no human body. So what I would like to share with you, whenever you want to go for making some legislations before parliamentarian, you should know larger interests of the society, social interest, culture, civilization, all in all should be known to you. When you have ignored all these, look at the peripheral issues in the society. And you are answerable to your kids at home. This is very important. You are answerable to the future and young generation as well. So what I would like to share with you, whenever you want to go for making some legislations at the higher level, you should be careful. This is one thing. What is the procedure for filing a PL, public interest litigation? How exactly public interest litigations are going to be filed? What kind of procedure you have and substantive measures you have? This is very crucial. First of all, you have to identify the issue. What kind of issue you have? Issues in connection to women, children, orphans, LGBT sex, internally displaced persons, refugees, for example, sometimes. Issues in connection to subject matter of pollution, maybe water pollution, air pollution, sound pollution, noise pollution, or marine pollution, such the things you may be finding. First of all, you have to find out the what kind of public interest litigation you have. You have to identify the issue as such. What kind of issue you have? This is one thing. You have to research and gather information. Adequate research is highly essential. It might be from on the basis of doctrinal or non-doctrinal, quantitative or qualitative, uh, deductive or inductive. So these are the major aspects which shall also be actually looked upon. Apart from this, you should have a reflective thinking, scientific thoughts, or ultimate truth whenever you want to go for filing, PAL before honorable courts are concerned. It means that adequate research is must when you are just filing a petition before honorable courts as well. And you should have at least a general information when you're just filing public interest litigations are concerned. Once you have gone through all this, you have to consult a lawyer, talk to him, share your views. So based on your views or issues, he may frame a draft that could be actually filed before honorable courts as well. An affidavit shall be actually filed with the supporting documents as well. So without evidences, you may not be finding a justice before the court of law. Either it could be oral evidence or documentary evidences shall also be actually filed before the court of law as such. Apart from these, fact in issue or relevancy of facts shall also be actually helpful to file a case. This is one thing. Based on above, you can file a petition under Article 226 and 227. You'll be filing your PAL before high courts in the sense that High Court of Karnataka, High Court of Madras, Tamil Nadu, High Court of Andhra Pradesh, High Court of Kerala. So likewise, you can file. Under Article 32, you'll be moving to Honorable Supreme Court of India as such. This is what Article 32 is very clear. Article 32, that itself is a fundamental right. This is what Dr. B.R. Ambedkar has already been outspoken by saying that Article 32, that itself is the Constitution, the heart of the Constitution. Article 32, that itself is the heart of the Constitution. So without remedies, whatever you are guaranteed under the Constitution of India would be incomplete. So therefore, right to remedy, that itself is a fundamental right. So that has to be looked upon. So based on filing a case, a notice can be served to respondents. A person who is actually filing a case shall be called as a petitioner. The people who want to counteract with a petitioner shall be called as respondents. A notice has to be served to the respondents. Look at the court hearing. So once the case is actually resolved with many merits of the case, then you can get a decision. I mean to say that justice as well. This is highly procedural, and you should know procedure how to file public interest litigation before the court as well. Details to cleared for drafting a case as well. You should see the petitioner's name, postal address, email address, phone number, occupation, annual income, the PAN number, all in all should be given to them. Then proof of identity of petitioner must be annexed. The facts of the case, nature of the inquiry, any personal interest that he or she, it may be there, you have to be clear. Then details of any litigation involving petition which would have a legal nexus with the issue involved in the PAL, that has to be clear. Then a class of persons for whom the benefit the PAL is actually being filed, how they are incapable of accessing the courts themselves. Suppose you are filing a case on behalf of the group of people or the society. In such a situation, you should acknowledge if they are unable to file a case directly on behalf of the clients, I'm just appearing. This is what you have to argue on behalf of your clients before the court of law. In the event that any representations have been made to any authorities regarding the issue, the details of the same shall also be actually looked upon. I mean to say, when you are just filing PAL, a court should not have got some doubts. Through benefit of doubts, your petition can be rejected within no time. You have to be careful when you are just filing, PAL as well. Any person, body, institution that may be affected by PL must be joined as a party sometimes. Take an example. During the pendency of PAL, National Human Rights Commission, National Commission for Scheduled Caste, National Commission for Scheduled Tribe, National Commission for Women can intervene in the case as well. You have to allow them and you cannot reject them. Sometimes some organizations can intervene on the basis of an amicus query. When you are just filing amicus query, you should have lots of information as well, lots of merits of the cases, grounds for filing amicus query as such. Otherwise, your petition can be rejected within no time. This is one thing you should understand it. So what are the important features of PL in India we have? Look at, anyone can file a PL. However, you should have grounds, number one. You should have wide ambit of issues. With you to reach out your own goals based on distributive and corrective of justice. So these are the things that shall also be looked. So what kind of matters shall be entertained by PAL, public interest litigation? Look at bonded labor matters, neglected children like orphans, children of, primitive tribals. Then no payment of minimum wage to workers, exploitations of the casual workers, atrocities on women, environmental pollution, disturbances of the ecological balances, food adulterations, maintenance of heritage and culture. So these are the areas should be brought within the limits of PL, public interest litigations are concerned. Once you have gone through all these issues, you are liberal to file a petition before the court of law as such. Apart from these, as I said and shared, what is PL? What is the purpose behind? What are the features of a PL? Then what kind of procedure shall be looked upon? Once you have gone through all these perennial or comprehensive questions, then you can share few views based on judicial pronouncements. I mean to say that judicial activism. Through judicial activism, PL can be heard before the court of law. That's very important. If something has gone wrong in the society, someone should come forward with a societal interest to overcome all these issues and challenges as well. Because I'm not living alone, I'm living with many people. That I should know it. This is one thing. On the other hand, the Kriya and Karma shall be known to you. Kriya for yourself, Karma for others. One owes a duty towards others. We have gone through our own responsibilities towards others. That's why lots of public interest litigations are actually filed before the court of law. Why these cases are relying on? Take for an example, Ushenara Cartoon versus State of Bihar's case. This case was actually filed before Honorable Supreme Court of India with a view to understand inhuman conditions of prisoners and under trial prisoners as well. You know that the situations in prisons as well, when a person who has committed a wrong may be sent for judicial custody. When he is in judicial custody, he should be treated humanly. This is what law says. Fair trial, that itself is a human right and fundamental right as well. That has to be looked into. Otherwise, it's a gross violation of human rights as well. So therefore, in this particular case, this was actually first reported instance of a PIL in India, which brought attention to the issue of inhuman conditions of prisoners and under trial prisoners as well. When there is a gross violation of these people, you can file a case before the court of law. In Vishaka versus State of Rajasthan, perhaps many teachers may have heard about this case. This case is actually related to the issue of sexual harassment in the workplace. As a result, Vishaka guidelines came into effect, published in 1997, which provided employees with the definition of sexual harassment, a list of preventive strategies and information on filing complaints of workplace sexual harassment as well. When we were deciding this case, we couldn't find a single definition on sexual harassment at working places. Fortunately, India was one of the member countries of CEDA, Convention on Elimination of All Forms of Discrimination Against Women, 1979 as such. Thanks to Honorable Supreme Court of India, with a view to define what you mean by sexual harassment at working places are concerned. Through this case, through this pale public litigation, especially in India, women are actually liberated in the sense that they can walk a little even at midnight. So such kind of PL was actually public litigation was actually filed before Honorable Supreme Court of India with a view to clear some doubts in connection to subject matter of the harassment at working places are concerned. So based on this case, in 1913, Parliament was able to pass a very good legislation with a view to understand sexual harassment at working places as well. Now, women in India can work freely in any public place or private place as well. So, such kind of protections are actually being considered country like India. It was because of a bail which was filed before Honorable Supreme Court of India, especially in the Vishaka versus State of Rajasthan's case. As a glaring example, I'm just sharing with you. Look at MC Mehta versus Union of India. This case is related to pollution in Ganga's basin. The judgment criticized the local government for giving permission for untreated sewage from Kanpur's Tenaris to enter the Ganges. Directions were given to prevent the consequences of water and air pollution on millions of people in Ganga basin and emphasize need for sustainable development as well. This was possible when MC Mehta, a common lawyer who could file PL before Honorable Supreme Court of India with a view to understand crisis in connection to the subject matter of pollution as well. Of course, no matter, there are series of principles have come through to understand the protection and preservation of human environment country like India. Though we have all these legislations and the practical implications, crisis in connection to the subject matter of environment are remained, and who has to clear and who is this responsibility as well. All these things shall also be actually looked upon. So therefore, if rather I would say, first of all, you should know where exactly we have come from. Then only you appreciate yourself, where are you going. This is one thing. God has given everything. Look at divine law. So divine law has already been given everything. Only thing is that you should understand on the basis of man-made law. Rule of jungle is different from rule of law. You cannot mix them in otherwise manner as long as you are living on this earth planet as well. You should see your surrounding circumstances. Your surrounding circumstances should be clean. That's your responsibility. Shouldered on you. That's the karma you have, dharma you have. Look at in earlier days when you just go back to ancient history. Look into Yagnavalkya Smriti, Manusmriti, Narada Smriti, Kautilya's Arthashastra, Vedas, Upanishads. They have outspoken on protection and preservation of human environment, no matter. See, after having gone through the constitution in 1950, since then it is a debatable country like India. We have passed so many legislations with you to preserve and protect human environment. However, pollution effluents are actually being continued. So therefore, being a human being who has come from social interest or public interest, you are liberal to file a PAL before honorable courts to seek justice, or for the survival of entire mass, you can file. This was possible when MC Mehta was a small lawyer, I mean to say that petty lawyer who could raise some objections before Honorable Supreme Court with a view to understand the human environment country like India as such. So apart from his ideologies, series of legislations have been actually brought in based on PAL as well. Look at in Paramnand Katara versus Union of India. This case was actually filed to facilitate hospitals to handle emergency accident cases without concern for pending police investigations. The judgment made it obligatory for a hospital or doctor, public or private, to provide immediate medical aid to a road accident victims. This is the concern one should show. The humanity has to be looked upon. Humanity and consideration shall be made available when a person has been actually affected by any one of them. So therefore, in this particular case, Paramananda Katara versus Union of India, the Supreme Court came out with new approaches with you to understand the immediate medical assistance to a common man as well. In earlier days, what had happened? You were waiting for police investigation. Now, if somebody has got some problem, I mean to say, met an accident, immediately he can get relief from the agency as well. This is one thing. Apart from these, look into Javed versus State of Haryana. In this case, the constitutionality of population control provision governing the panchayat election was actually challenged. The Haryana provision disqualified persons having more than 2 children from holding certain offices in panchayat. Of course, no matter, time and again, if something has gone wrong to a public or social uh, concern, immediately you can. This is what in this particular case, Javed versus State of Haryana, the apex court or Supreme Court or higher judiciary has taken a very good step to come forward some issues are concerned. Apart from these aspects in which I have gone through, there are some challenges. There are as many as perennial or comprehensive or wider questions. As long as you are dealing with the subject matter of public interest litigations are concerned, then what kind of issues and challenges we have when you are dealing with public interest litigation as well. Sometimes people may misuse it. Sometimes it is because of these reasons you may find lack of justice before the court of law and overburdening of judiciary, limited effectiveness might be there. These are the major challenges or disadvantages we have when you are dealing with the public interest litigations are concerned. Dear colleagues, however, you may have had some categorical understandings about the subject matter of PAL. PAL is the basis. Without PAL, there is no survival at all. So therefore, one should understand public concern or social concern, without which how will be called as if a human being on this earth planet. So therefore, we have to understand in this perspective. Obviously, rather, I would say, however, you may have had some categorical observations here and there, you should understand law, society, and science and technology as well. So with these a few aspects, if something has gone wrong by the court, I mean to say the state or government in such a situation, you are liberal to file public interest litigations are concerned based on the society as such. You are living with society. This is one thing. At the end of this session, I would like to share with Leo Tolstoy approaches. What he says that one of the first conditions of the happiness is to bridge the gap between man and nature that shall not be broken off. So therefore, you have to grow naturally how plants and trees are growing Otherwise, you may not be called as a human being on this earth planet as such. I thank you, all of you, for giving me an opportunity to share. If you have got some questions, I'm liberal to answer you.
Sir, PIL ನಾವು registration ಮಾಡಬೇಕಾದ್ರೆ, so we have to go for only high court or in lower court also we can register PILs.
ನೀವು ಒಂದು ಅದು ಹೈಕೋರ್ಟ್ ಅಲ್ಲಿ ಹೋಗ್ಬೇಕಾದ್ರೆ ಆರ್ಟಿಕಲ್ 226 237 ಅಲ್ಲಿ ಹೋಗ್ತೀರಾ.
Okay.
ಅಲ್ಲಿ ಒಂದು 50 rupees ಏನೋ ಫೀಸ್ ಇದೆ, ಅದನ್ನ ಕಟ್ಟಿ ನೀವು ಹೋಗ್ಬೇಕಾಗ್ತದೆ. ನೀವು ಅದಕ್ಕಿಂತ ಮುಂಚೆ ನೀವು ಒಬ್ಬ ಲಾಯರ್ ಹಿಡಿಬೇಕಾಗ್ತದೆ.